Chapter 31. The Equity System of Pleading continued. Sec. 169. Some matters of history. Equity, as administered by the early English chancellors, was borrowed from the Roman law, and the one cannot be understood without some knowledge of the other. Mr. Pomeroy has said that modern juridical scholars have exposed the falsity of much that was written by English authors, Blackstone and Coke, with respect to the origin of the law, and have demonstrated that the closest relation existed between Roman jurisprudence and the early English common law. In the earliest period of the Roman law there were 5 actions for the enforcement of all civil rights, which were technical and formal, requiring absolute accuracy in complying with the established phrases and acts, any omission or mistake of a word or movement proving fatal. We are told that there was a strong resemblance between these Roman actions and the original real actions of the common law. In the Roman law there was no separate court or tribunal to administer equity, as in England, because the ordinary magistrates were willing to do what the early English common law judges utterly refused to do. Another fact showing the relations between Roman and English jurisprudence was the fact that the early common law judges, and the chancellors, following inclinations prompted by religious ties, drew very largely from the Roman law in constructing their jurisprudence. The ancient common law actions were the real actions and the personal actions, the latter consisting only of debt, covenant, trespass, detenue and rapine. These being the only actions, we can readily see that the common law at that time furnished but a meagre system of remedies, wholly insufficient for the needs of a country rapidly advancing beyond the dominating feudal ideas. The real actions were in fact inadequate, and the personal ones were still worse. No contract could be enforced unless it created a certain debt, or unless it was embodied in a sealed writing. There was no means furnished for the legal redress of a wrong to person or property unless the tortious act was accompanied with violence, express or implied. The great defect of the common law consisted in its inability to adapt its actual reliefs to the varying rights and duties of litigants. Whatever might be the form of action used, the remedy conferred by the judgment was either a recovery of the possession of the property, real or personal, or the recovery of money. Thus we see that the common law courts were closed against a large and steadily increasing class of rights and remedies, and a distinct tribunal, with broader and more equitable jurisdiction with a better mode of procedure, became an absolute necessity. Finally Parliament passed an act which brought about a great reform in common law procedure. It was the act authorizing the chancery clerks to invent new forms of writs, suitable to new conditions of fact, providing for remedying rights that were without means of enforcement. It was passed in the reign of Edward I, in the year 1285. This act provided as follows: whenever from henceforth it shall fortune in chancery that in one case a writ is found and in a like case failing under law, and requiring the remedy is found none, the clerks of the chancery shall agree in making the writ, or the plaintiff may adjourn it unto the next parliament, and by consent of men learned in the law a writ shall be made, lest it should happen after, that the court should long time fail to minister justice to complainants. This enactment was intended to accomplish much good, but the common law judges seemed to be against reform, and the only new remedies which were established under this enactment were case, trava, and assumpsit. These 3 actions were very far-reaching in effect and furnished litigants much greater relief than could be had in the old actions. We can readily see what reformation might be made in the common law procedure by the creation of case and assumpsit, when we know that at the present time the courts are principally occupied with causes of this nature. It was these 2 actions that mainly brought about a reconstruction of common law procedure. The actions of case and assumpsit were very much more flexible in their operation than any of the other personal actions, and had considerable to do with furthering the cause of equitable jurisdiction. This then was the condition of the common law when equity sprung up. Prior to the reign of Edward III in the year 1327, the practice of resorting to the chancellor for relief which could not be secured at common law was merely permissive. At first appeals were made to Edward I, year 1272. The reference to the chancellor established upon a legal and permanent jurisdiction. In the 22nd year of his reign in 1349, by a general writ, he ordered that all matters as were for grace should be referred to the Chancellor, so that the equity jurisprudence is usually spoken of as dating from the decree of Edward III. Courts of equity then acquired their jurisdiction at the beginning from the Crown, and the principles which the Chancellor was to follow were honesty, equity and conscience. Suits were instituted by bill without any writ. One of the predominant ideas of equity, being founded on the principle of conscience, was the protection of the poor, weak, helpless and oppressed against the rich and powerful. Consequently many things were done at the beginning which were rather extraordinary. The practice of addressing the suitors' bills or petitions directly to the Chancellor and not to the King did not begin until Richard II, in the year 1377. At about this time an Act of Parliament was passed which regulated the business of the court and restrained its actions somewhat. This was the first recognition by Parliament of the court as a separate and permanent tribunal. In the reign of Henry IV, 1461, the House of Commons made complaint that the Court of Chancery was usurping powers and invading the domain of the common law judges. Consequently a statute was passed curtailing the jurisdiction of the Chancery Court some. In the year 1461 the Court of Chancery was in full operation. There was constantly controversies between the two courts. A separate court of equity has finally disappeared in England and in most American states. The English Judicature Act passed in 1875 made changes in the courts uniting them all into one Supreme Court of Judicature and enacted that in every civil cause or matter, law and equity shall be concurrently administered. And it was also provided that when there is any conflict or variance between the rules of equity and the rules of the common law, with reference to the same matter, the rules of equity shall prevail. The notion was that equity was nothing more than the power possessed by the judges to decide according to the high standard of morality and right. This was the theory of the Roman law from which it came, and it was the theory adopted by the ecclesiastic chancellors. The states in their constitution recognize equity jurisdiction either in direct terms or indirectly. The jurisdiction of the United States courts is identical with that of the English High Court of Chancery at the time of the Revolution. In the states of Alabama, Delaware, Mississippi, New Jersey and Tennessee, the courts of chancery or equity are still maintained as separate courts. A history of the growth and administration of equity jurisdiction in the United States ought to be an interesting subject of inquiry by the student. Our forefathers regarded the common law as the bulwark of liberty, and were jealous of courts of equity, as were some of their ancestors in the mother country. They seemed to agree with Coke that the common law is the perfection of human reason, and sufficient for all cases, and with Selden that equity is a roughish thing, and therefore to be kept beyond the seas. But they experienced the same troubles with the administration of the common law as did their English ancestors, and so in the different colonies were established different tribunals having the general character of the English Court of Chancery, to administer justice according to conscience. Equity, good faith and honesty. As late as the middle of the 18th century it was claimed that there was no court of chancery granted by the Charter of New England, nor any court vested with power to determine cases in equity. There was no exact system of equity in the American colonies before the Revolution, and this condition was not improved in the States until the beginning of the present century. The system of equity in the United States was principally reduced to form by and through the labors of Chancellor Kent, who is designated as the father of American equity. Before equity became an established system of jurisprudence in this country, relief was afforded in matters not within the common law jurisdiction, by the governors, or committees from the legislatures, or the governor and his council. This was very unpopular, but it continued to be administered in this form until in New York in March, 1778, it was organized under the Constitution of the state. The doctrines of equity which form the basis of decision in the American equity system of jurisprudence, were principally declared and formulated by Chancellor Kent and Mr. Justice Story, the former as Chancellor and the latter as author of the first American treatise on the subject.